This discussion will cover malpractice coverage, insurance credentialing and insurance contract negotiation, billing company contract negotiation, and EMR contract negotiation. So first, let's cover malpractice insurance. First, what are your options? There's two main kinds. One is called, this is for malpractice, of course, claims made insurance and occurrence insurance. Let's talk first about claims made. That's coverage for malpractice during the term of the policy. And premiums are typically judged based on past and current experience of the practitioner. So again, you might of course end up with higher premiums if there's a history of lawsuits and cost associated with your services. Premiums are relatively low for your first few years of practice because again, there's no history there of cost. And as most know, insurance is based on risk and risk pooling. So the riskier you are, the more expensive your insurance would be, and the less risky you are, theoretically the less expensive your insurance would be. The big distinction between claims made and occurrence coverage is the timing of the coverage. Claims made, as I mentioned, is coverage for malpractice that occurs during the term of the policy. So if there is a termination of the policy, as a practical matter, that would mean a termination of employment at the practice. That would require, for a claims made policy, would require tail insurance. That is coverage for claims that are reported after the end of the policy period. So if you're an employed physician or an owner of a practice and you leave the practice, tail insurance would be required if the practice at the time is maintaining claims made coverage for you. The rule of thumb on tail insurance is that it's 2 to 3 times the cost of the premium for your insurance. So it is expensive. It is the type of thing that is negotiated during either employment agreement negotiations prior to joining a practice or once a physician, in my experience, sees the bill for one, they immediately want to talk about it with their next practice if they haven't already signed an employment contract. So something to be very cognizant of when dealing with claims made insurance. And anecdotally, I would say that claims made insurance is more common than occurrence coverage in terms of used in Florida. Generally, I would say that's because of the difference in cost. Occurrence coverage is more expensive, and here's why. Occurrence coverage is tied to, no pun intended, when the issue that gave rise to the injury occurred, regardless of when the claim is filed. So it stands to reason that tail insurance, of course, is not required because, again, we have a tie to the occurrence, not to the lapsing of a policy. Here, tail coverage is, again, not needed. And I should also mention that in addition to the concept of tail coverage that exists, there's also the concept of nose coverage, which not surprisingly is the opposite of tail coverage. Instead of being added sort of at the end of a policy, the nose coverage can actually be added to an existing policy, and it actually looks back, so to speak, to a time period that existed prior to the coverage at issue. You do, of course, still need to consider retroactive coverage like nose coverage, even when moving into an occurrence policy, because you're always going to want to deal with any prior acts. Other kinds of insurance coverage that are important to consider as the world of healthcare has evolved. These are things that not exceptionally long ago, especially the first two there, did not even really exist fundamentally in the insurance world. Fraud and abuse coverage has become popular. This is for violations of the Stark Law, HIPAA, which we'll get to in cybersecurity, the anti-kickback statute, and related fraud and abuse laws, both federal and state. Now remember, the devil's in the details here. So coverage and restrictions are all governed by your insurance policy. That goes for your malpractice coverage and any of these other kinds of coverage. So the key is to know what is covered and what isn't. An example of that would be if one has fraud and abuse coverage, there is usually an exclusion for intentional acts, not surprisingly. So that would just be one example. Another area of insurance that has become more prevalent lately is cybersecurity. We've all heard of all of these different kinds of issues surrounding identity theft and some of these other issues. Healthcare is, of course, no different. So this is coverage for computer hacking, for HIPAA breaches, which just continue to increase, significant costs associated with both fraud and abuse violations and cybersecurity related issues. Not only is it costly to deal with these things, having lawyers and other advisors involved, but also there are significant fines that can be assessed, so coverage can be important and can be a good investment for these types of issues. Old tried and true forms would be general liability, so for things like slip and falls while leaving the office, children slamming their hands in the door. Those are just, of course, a couple of examples of where general liability insurance can assist. And of course, another tried and true would be insurance from employment practices. Let's turn to insurance payer contract credentialing. So this again is for those insurance companies. This is another area that has changed immensely over the last few years. Leverage and the manner in which a practice gets leverage or obtains it, if it even can, has changed immensely. Being a small practice or a solo practitioner is much, much different in terms of leverage and negotiation than it is for a mid-size or larger practice. And we'll get into a little bit of the details of leverage over the next few minutes. So the importance of these, of course, is unless you're one who accepts only cash for services, which is, again, not as common all over Florida, this is how you get paid. Whether it's Medicare, Medicaid, although there's really no negotiation when it comes to those, but your private insurance contracts, this is how you get paid for the services that you render. And most insurance companies, from a mechanical and procedural standpoint, require the physician to complete an application that covers information such as your state license, your DEA license, your board certification, work history, things of that nature, your malpractice insurance face sheet. This is just that demographic information to, quite frankly, make sure you're somebody that they want. The negotiation, this is really where the devil is in the details again. Overhead costs, just in terms of operating a medical practice, continue to increase. It's tough out there to stay compliant, and reimbursement as a general matter often is not increasing, and that's a difficult mix. Negotiation, as I mentioned, has become far more complicated. So we'll talk a little bit about leverage, and these are questions that you need to ask yourself of your practice. Where are the areas and the strengths, and of course also the weaknesses from a negotiation perspective? Do you have a patient mix that is unique? What is it that can speak to the insurance company that can help you get a seat at the discussion table? Is there a service line in terms of the services that you provide that's unique to your area? Are there a number of similar providers in the area? So just to use an extreme to illustrate, physicians in rural areas, for example, let's say there's only one ENT in a 50-mile radius. He or she may have an easier time, as a theoretical matter, negotiating insurance contracts than that same ENT in an urban area when there are 15 different ENTs performing the same services to that same service area. The insurance company may have an easier time doing without the one who's being difficult in the negotiation process. Whereas, of course, there's leverage if you're the only game in town. So there's an example of where leverage can come in. So those are certain areas to pay attention to, and again, to think about, ask yourself about your own practice in terms of where you might have leverage. As far as insurance rates, many insurance rates are a percentage of Medicare, but there are also completely separate fee schedules based on services that don't have anything to do with the percentage of Medicare. So again, questions to ask, things to be mindful of. I want to touch just briefly on antitrust rules, to be very careful about sharing reimbursement information with other physicians and other physician practices. The antitrust rules, as a general matter, prohibit that if you're competitors. So important to check with your advisors when going through these types of things. There are a bunch of nuances and things you must be sensitive to. People get in trouble for these kinds of things, so something to be mindful of. Now let's cover a few lesser known terms to consider negotiating. I know a lot of time is spent on what is my insurance rate going to be, my reimbursement rate going to be. But these provisions like this are just as important. Authorization timelines and the process for treatment. How many times have physicians complained, certainly to me, about the difficulties with insurance company authorization for services? So that's a very important thing to consider negotiating. The period that's specified for submitting claims, you want to make sure that you have a reasonable time frame to be able to submit claims. The period that's allowed to appeal a denied claim, again, you don't want that time frame to be too short because you waive your right to appeal. Time specified for timely payment and whether the insurance company would be charged interest for not paying on time. Again, important concepts to consider. Lesser known provisions, maybe not as attractive as those numbers that you get for reimbursement, but can impact your bottom line just the same way. Also, the process for adding new service lines or for adding new physicians to the insurance contract. These are things that can get people and practices caught up in a web of complication. For example, you want to employ a new physician. You want to get that the physician signs a new employment agreement. All of a sudden, what's the first thing you want to do? You want to get that physician rolling within your practice. Well, the problem is you also have to get that physician credentialed. So you want that time frame to be as short as possible, and you want that process to be as easy as possible. Another very important one that continues to become very prevalent in my world is the look-back period for alleged overpayments. Healthcare audits are white hot, and they remain a challenge, and they're costly, and they're stressful. They can shut your practice down. So look-back period and appeal process for alleged overpayments, again, a very important area to be cognizant of and consider negotiation. At a minimum on these provisions, know what you're signing. Even if the insurance company says we're not going to negotiate one word of this with you, it's very, very important to know what you're signing. That goes for any contract, and this is just an important example of that. Another example here, one that we see very commonly nowadays, is the period required for providing notice of amendments to the contract. This is one that we are seeing a lot of now. It is a provision that essentially says that the insurance company will provide you with X days notice of proposed changes or amendments to the contract. And generally, these provisions will say that you have X number of days to oppose that provision. And if you don't, it's considered a binding change. So that when you get those things in the mail, that's what some of these things say. So again, that's why I say this one is a bit sneaky. Now, there are options that not only if you oppose, but then there are options essentially, potentially for termination if you oppose. But again, that type of provision is an important thing to be cognizant of. They're the things that you find out about when it's going against you. The termination clause, including advance notice, is very important as well. If the insurance company is going to terminate you, most, if not all, insurance contracts do have what's called a termination without cause provision, meaning the insurance company can terminate you just because it feels like it wants to. It would be good to have a reasonable heads up that that's going to happen so you can make arrangements to deal with this in some form or fashion. So very, very important. Also, as part of that, restrictive covenants such as non-solicitations are very, very important. There are sometimes provisions in the contracts that prohibit you from soliciting your patients that are covered by that insurance company to let them know that you will no longer be a provider of that insurance. So you can imagine how that can be very important. Automatically adding other products that you may want. For example, adding an HMO to a fee-for-service contract. Other things that we find in there. Record retention requirements. If I had a nickel for every time I was asked how long I have to keep my records for medical practices, those run across the board. Again, it goes a little bit outside the scope of this to get deep into that analysis, but one of the things we do mention and look at is the provisions in insurance contracts. Dispute resolution, I mentioned appeals. This is another important spot. So not only would one appeal an alleged overpayment in the dispute resolution process, but you may also appeal your termination or really anything that goes on in the contract. Typically, there is a closed, what I call a closed arbitration, meaning there's a process within the insurance company that you must first go through before you can get to court if you think you've been wronged by the insurance company. Oftentimes, the judge is the same as the plaintiff in that, if you think about it, because the insurance company has a panel that you end up appealing to. Sometimes they work out, sometimes they don't. So it's another spot to, again, at a minimum, be cognizant of. The reason I have that subpoint there is a jury better than closed arbitration. Well, again, when your judge is the same as the plaintiff, you can imagine how that tends to go, and at least a jury of your peers can be theoretically a little bit more objective. So we'll turn now to billing companies. We are seeing certainly more and more practices, large and small, because billing has gotten so complicated and CPT code compliance has gotten so complicated and it's constantly changing almost on a day-to-day basis, we are seeing more and more practices align with third-party billing companies to assist with day-to-day operations in the billing context. One thing that I cannot caution physicians on enough is make sure that whoever is doing your billing knows what they are doing, because these are the types of things that get people in trouble and shut down practices. So the pros of an outside billing company would be, again, you can focus on patient care, especially for the smaller practices. This allows you to focus on your patient care. It reduces your billing errors as a theoretical matter if you have the right person. It can reduce your compliance risk as a theoretical matter. And it can increase your revenue because you would be spending less money dealing with audits and overpayment related issues, and would have more efficiency as it relates to appropriate billing. Cons, less control. That can sometimes be an issue for people. It can be more complicated for patients to pay because, as we'll get into, billing companies also often have a component where they will assist with accounts receivable for patients. There is a HIPAA breach risk, an additional one. You've already got your own to deal with. Now you've got a billing company that patient information is being sent to. So it's just another player in the game here where there is some risk from a HIPAA perspective. And overall, you can also have increased compliance risk because, again, we're dealing with billing and coding here. So if the billing company messes up, it can still be your problem. So potential risk there. So certain criteria to consider at the outset when considering a billing company is certification. This is just one example of one of sort of the national clearinghouses. This is the Healthcare Billing and Management Executive. It's just one example. Again, there are a handful of nationally recognized organizations when it comes to certified billing, so something to pay attention to. HIPAA compliance, again, very, very important. Fines and penalties are significant when it comes to HIPAA breaches, so very important that the billing company be HIPAA compliant. You'll also want somebody who's well-versed in data analytics, to assist in revenue cycle assessment, because again, this is your business, this is cash flow, so you're going to want somebody who's experienced on the business side. Having experience with EHRs, and most particularly your EHR, to the extent you're ever going to have questions. This is kind of like getting a tune-up when you have the right billing company, because they can assist you and always help you improve, whether it's if they notice things with your note-taking that could be improved, or maybe there's a consistent issue with certain E&M visits that you're billing or something of that nature. So having experience with the EHR and how they can help you be more efficient with it is also helpful. And always important with any vendor. Ask for a list of vendors' clients. Don't be afraid to contact other physician groups to ask how things are going with the particular billing company. So a couple of contractual considerations to consider. First, the level of service. What will the billing company be doing for you in your practice? This is a list of the type of things, not exhaustive, that are typically covered in billing company contracts. So submission of claims. Will they pursue denied claims? Will they handle billing follow-up, whether that's with insurance companies or the patients? Will they assist with regulatory compliance? That's one to be very careful with, because again, this is not easy stuff. CPT code compliance is very, very important. And will you receive reports and analysis? Fees. Most commonly, we would see percentage-based. Now, of course, that is for billing companies that are not part of larger management companies that also provide marketing services. Big thing to worry about and pay attention for. You do not want percentage fees when there's marketing out there. Again, that goes outside the scope of this discussion, but something to be cognizant of because of those pesky fraud and abuse laws. So other options are fixed fee, and there are, of course, hybrids of that as well. You would tend to see a more fixed fee when you would see a billing company that may also be part of a larger group that may also handle marketing. Term and termination, one of the most important components of any contract is how do you get in and how do you get out. So in the billing company context, one of the unique components of it is also there's typically a provision, and it's really beneficial for both parties. How long will the billing company continue collection efforts following termination? Sometimes you see 3 months, sometimes you see 6 months, which I would say is anecdotally probably the most common, because again, the billing company wants to make sure it gets paid for the service that it provides. When you think about the lag time of 90 to 180 days for most insurance payers, the billing company will assist post-termination in getting those claims paid because, as a theoretical matter, those are the ones that have been billed by the billing company. You'll also want representations and warranties in the billing contract regarding HIPAA compliance and accuracy of coding. Again, this can be driven and negotiated based on the level of service that the billing company is going to provide, but you're almost always going to want HIPAA compliance in there. Warranties and limitations on liability. This one is very, very important. This is good old-fashioned risk shifting. So the practice is typically going to have to warrant or represent that it is responsible for the accuracy of information that it provides to the billing company. Most billing companies, I will not say all, but most billing companies are sort of what I would call a plug and chug type variety in that they will assist with the mechanics of handling the billing. They will not necessarily guide on a day-to-day basis or assess and analyze what is being billed by the practice. They will just take the data that is provided by the practice and handle the billing, monitor, and assist with it. So very, very important to know that typically by contract, it is made clear that the physician practice is responsible for what it submits to the billing company. Again, that can be different depending on the level of service that the billing company provides. Insurance or bonding, you'll want to know that if there is a problem that with the billing company and they have messed up, that they have insurance or bonding for those issues. Just like we talked about in a prior discussion, having insurance is very, very important, different kinds of insurance. The billing company is really in no different spot. And audit rights, you may need to have a look at their books and records, so you want to make sure that there's provision for audit rights. Now let's turn to EMR contracts. I would say first and foremost, you want to make sure that your software vendor for your EMR is certified. That's very, very important for the famous meaningful use payments that the government put out as part of healthcare reform. There have been a couple of cases that have come out where significant dollar amounts were paid back to the government because EMR companies lied to physician groups and other healthcare providers about being certified. So this is a very important area. Not only is it important for your meaningful use, but of course it's important for the protection of the practice when, again, it comes to HIPAA, privacy, and other things of that nature. Responsibility for safety and security, very, very important. Make sure that this is not something that's left solely to your practice. You want the EMR company to be responsible for safety and security of the EMR. They are the ones who are providing the software to the practice. Ensuring safe implementation. The vendor should be required to maintain internal controls to ensure quality software, timely notice of any issues or changes in the software, and they need to provide adequate training. I will mention that holistically, it has become difficult to negotiate with EMR companies, almost from the outset of healthcare reform when they became more ubiquitous. They tend not to want to negotiate many of the provisions in their contracts. You'll see this is another spot where it's very, very important to know what you're signing because the risk can be significant. So I always say the answer is no if you don't ask. So I would never suggest we don't negotiate at all. But it's, again, important at a minimum to know where the strengths are and where the weaknesses are within the contract, no matter how it ends after negotiation. More provisions are secure implementation and use. So the time frames of which the vendor must respond to an issue. Again, these are the types of things that can paralyze a practice. You don't want to have to wait 3 days if your EMR locks up. Imagine what that's like for patient care. Warranties and limitations on liability. This is probably, in my view, the most negotiated area from my perspective in EMR contracts because it is often so difficult to negotiate the other portions. What you'll often see is what I got a couple of quotes here that I pulled out from contracts. Except as set forth herein, that's lawyer language for you. Vendor makes no warranties as to, so meaning that unless it's set out in the contract, the vendor is not making any promises as to the viability of the software. The next one is vendor's liability hereunder shall not exceed. So that's where the vendor is going to cap its liability under the contract, no matter what happens. I've even seen, and it's not uncommon to see, that the vendor will even cap its liability for its own negligence. Now that can be litigated sometimes, but it is difficult and you're adding cost, expense, and stress when you have to get into litigation. So this is risk shifting at its finest. This is saying we're going to provide you with software, but we really aren't going to we're only going to take the responsibility that we're setting out in the contract. Sometimes they can set really low caps, so very, very important. This rears its head if there's a HIPAA breach, for example. Let's say there's a HIPAA breach that affects 3,000 patients, and the total liability for the EMR vendor is capped at 6 months of EMR license payments that the practice has made. Well, at an average of $300 to $400 per patient record for a HIPAA breach, not including fines potentially, you can see how your liability to the government and to your patients could end up far exceeding the amount you could turn around and get back under the contract from the EMR vendor. So a very important provision and something to be cognizant of. A few others, as if you hadn't had enough yet. Quality and timeliness of the service, that's again important. These are the types of things that can paralyze your practice. Non-infringement on third-party intellectual property rights. That's a tongue twister. What that one means is you want it to be made clear that the software does not infringe on another company's software rights. In other words, that this is the invention, so to speak, of your EMR company, and that they will protect you if an issue arises, if you're a user of this software. Compliance with law, you'll notice a trend there that's always important in these healthcare contracts. HIPAA and meaningful use, as we talked about, similar types of things. If they cause a breach of some kind or some other issue as it relates to compliance, you want to have recourse under the contract. What is their insurance coverage? You want to make sure that they can pay. Now, again, what we have seen is they may have insurance coverage, but they may have low insurance coverage. Why? Because they have capped their liability at a relatively low number. So things to pay attention to, and you can see how these all kind of play together. Speaking of playing together, interoperability is another important one. You want to make sure as EMRs become more ubiquitous in healthcare and interoperability becomes even more of a focus. It was supposed to be a focus all the way at the beginning. You're seeing more of it now. You want to be able to make sure that your EMR is married to the hospital's EMR. So you want to get some sense of the interoperability of your EMR system, and what does your contract say about that? Dispute resolution, that becomes important, of course, if there is an issue of some kind. So what does the complaint chain look like when there's an issue? And the business associate agreement, I want to make sure we touch on that. Very, very important. For the billing company that we talked about before and for the EMR company, most likely. Anytime you have a vendor of some kind and the exchange of protected health information, of patient information, is involved in that relationship, you're likely going to need a business associate agreement with that vendor. That's another contract that should be negotiated. Now, most of the time when they're properly drafted, they are drafted sort of to tie into the HIPAA requirements. There's not a ton that needs to be negotiated, but that you can often negotiate and often need to negotiate who is liable for costs if there's a breach. How many days, for example, does your EMR vendor have before it has to notify you of the breach? Things of that nature are found in the business associate agreement, and you can see where it becomes important if you have a problem. So not only are they required by HIPAA, is there a legal requirement, but it's also very, very important as it marries into these types of contracts. So a very important separate contract. Transition issues are also important. This is another spot where we've seen some issues post-termination. So you decide it's time to move on to another EMR vendor. What is life like when it comes to that transition? As with all contracts, the best time to negotiate the end of the relationship is before you've even started the relationship. The big issue I would see here, one, is you've got the transition services. As a theoretical matter, you've got a passive-aggressive vendor who just had their contract terminated, but you want to make sure that they are contractually obligated to assist you with the transition. The other really important one is data portability. What you'll often see in these contracts is that the EMR company will offer to provide the data in a format that cannot be manipulated, so to speak, and I mean that in the good way, that cannot be used in a new EMR. So in other words, it could be provided almost in paper form, such that you have to start from scratch with your new EMR. In a perfect world, of course, you'd like to be able to just transfer your current EMR and the substance of your EMR into the new one so you can continue to treat patients as seamlessly as possible. Many will do that, but they will charge a hefty fee. So again, at least be cognizant of it, and at best, negotiate that.